social security system in Turkey is predominantly similar to a Bismarck model, but also have some elements from the Mediterranean model. Generally speaking, it refers to a system where the premiums paid over the wages of the employees according to their insurance status are collected in a joint pool, and the benefits are provided based on the paid premiums in cases of retirement, accidents, sickness, and maternity, etc. Well, why are we talking about the social security system and social security organizations in these occupational accident issues? What's its relevance? Well, the main issue is that, as I will be getting into its details, the social security organization may allocate an income or an aid to the injured seafarer or their beneficiaries in the event of fatal occupational accidents. Well, see, the financial contribution made by the SSO also forms a part of the material compensation claimable under our local law. That is to say that whether or not the SSO will involve the matter or what their share will be if they are going to has an impact over the compensation, the material compensation that will be paid by the members, the clubs. And to avoid the duplicity in payment, the circumstances must be assessed, evaluated in proper manner. When the vessel is flying under Turkish flag and in the event of a work accident of a Turkish seafarer, the SSO's involvement is inevitable. Pursuant to the relevant regulations, the SSO allocates a certain amount of income to the dependents of the deceased seafarer or the injured seafarer himself, provided that the criteria in the Social Security Organization are met. Well, in accordance with the relevant provisions, the SSO is legally entitled to initiate a recovery action against the liable employers. Well, for that reason, there is a huge possibility in the event of SSO's involvement, a recovery action to be brought by the SSO. The time bar for such actions would be 10 years as of the date of the allocation of income. Well, whilst making these assessments, SSO inspectors release a report where the findings evaluated on whether the accident fall under the scope of work accident, and if so, what is the fault ratios of the concerned parties. As later on, the SSO has the right to recourse to the employer. The findings in the SSO's reports are not entirely binding for the employers. It's rather an internal report for the SSO than being objectively binding. Well, when the vessel is flying under foreign flag and a Turkish seafarer had an occupational accident, the matter is not very straightforward. Well, in the past practice, it was simple. If a Turkish crew was working on board a foreign flagged vessel, he had not been covered by the system of SSO. However, in 2016, the SSO clarified the legal status of the seafarers via a circular. Well, albeit the circular may be criticized for its legal accuracy, it's clear that the SSO will base its practice based on the principles set out in that circular. Without getting lost in too much detail, we may briefly summarize that if there is no bilateral social security agreement between the flag state and Turkey, and the Turkish company is a bareboat charterer or crew manager by providing safety trainings, remitting the salaries, etc., the seafarer having Turkish nationality will be deemed to be insurance holder under the Social Insurance Act. Not only its practice being grey, but also it has got a retroactive effect. Thus, in such cases, For proper assessment of material compensation amount and to avoid duplicity in payment for the owners and club's account, it is important to evaluate the circumstances properly. Beyond any doubt, the most valuable thing in life is life of a living being. Plants, animals, humans as a part of animal family. To safeguard the human life and physical and psychological well-being at the workplace is an essential human right. I feel safe to say when I said Turkish national regulations on labor law are in compliance with the international standards. Turkey is a party to many international conventions and member to many international organizations relating to employee rights, safe working environments, and decent working conditions. When it comes to the application of these regulations, Turkish courts have tendency to interpret the circumstances in favor of the employees and/or their families to safeguard them before powerful employers. Considering the lack of supervision at the workplaces, illicit work, and general economic conditions, it's an understandable attitude on the court side. Furthermore, these sorts of accidents also attracts media attentions. Recently, some of the work-related accidents in the shipping industry have been a hot topic. Perhaps you may have heard some of those. Eventually, such public pressure has an effect over the judicial bodies, even unwittingly. Well, of course, these have some effects over the implementation of the regulations. One of the reflections of such attitude is to intervene the conditions of contractual relations between the employers and employees. Well, under the employment relationships in Turkish law, if contractual benefit is lower than the legal benefit, then the conditions in the contracts will become null and void. If the contractual benefit is higher than the legal benefit, then the conditions in the contract will prevail. Well, also, another example for that would be in the event of natural deaths at the workplace. Despite the lack of causal link, the Turkish courts may have tendency to interpret the circumstances in favor of the employees, their families, and still rule a compensation in favor of them. To summarize, there are many elements to consider when an occupational accident took place. By way of this video, it's aimed to provide a helicopter view of occupational accidents and the liability arising thereof. For particular cases, our contact details can be found on our website, and our LinkedIn posts may be followed for recent updates regarding the shipping industry. Thank you for watching.